As a result of this decision, that's the law of the land, at least in the Fifth Circuit, is you can't be counting ballots that arrive after Election Day. Well, now on to some good news when it comes to the rule of law and election integrity. We had two decisions in recent weeks related to election integrity. The first one, as it relates to Judicial Watch, was over our lawsuit to end the counting of ballots received after Election Day. We had a lawsuit in Illinois. It's on appeal now because the court said a member of Congress who is a candidate doesn't have standing to challenge illegal vote counting, which is crazy. In Illinois, they count ballots that arrive for up to 14 days after Election Day. In Mississippi, they count ballots that arrive for up to 5 days after Election Day. California, 7 days after Election Day. And we just sued in California over that for Darrell Issa. And in our lawsuit, we alleged there were two congressional races whose results were changed and Republicans lost as a result. And those results were changed as a result of ballots that were unlawfully counted because they were counted despite arriving after Election Day. But the good news is that we had an affirmation or reaffirmation in a dramatic way in our Mississippi case. So in February of last year, we've sued. And then in October of last year, essentially the case went up to the Fifth Circuit Court of Appeals. And in that case, we're representing the Libertarian Party. And in Mississippi, the Libertarian Party sued, saying counting ballots that arrive for up to 5 days after Election Day violates the plain federal law that sets Election Day as, quote, a day. And if the ballots aren't there by that day, too late. And the appellate court indeed did rule on October 25th, 2024, that Congress statutorily designated a singular day for the election of members of Congress and the appointment of presidential electors. Text, precedent, and historical practice confirm this day for the election is the day by which ballots must be both cast by voters and received by state officials. Because Mississippi statute allows ballot receipt up to 5 days after federal election day, it is preempted by federal law. We reverse the district court's contrary judgment and remand for further proceedings. So that was a massive win. It was the first appellate ruling finding the counting of ballots after Election Day is contrary to federal law. It's unlawful. So there was an appeal. Now, when an appellate court rules against you, a three-judge panel here, I'm not a lawyer, so take this for what it's worth, because I'm sure there's a lawyer out there who's going to think of an exception to what I'm about to say. But generally speaking, you can appeal straight to the Supreme Court, or you can ask the full Fifth Circuit Court of Appeals. So the Court of Appeals has more than just three judges who hear an individual case. There's a whole slew of them. And depending on the appellate court, they have, the numbers change depending on the size of the appellate court and their jurisdiction. California's got an entire Congress worth of judges, it seems to me, at the appellate court level. But you can appeal to the full court. You can say to the appellate court, take a look at this panel decision, and the full court should consider it. And this is in lieu, at least, or it's one step you can take before appealing it to the Supreme Court if you want. And that's what happened here. They asked the full court to hear it en banc, which is literally what that means, the full court hearing it. And the court rejected the request to rehear it by a vote of, I think it was 5-10. So only 5 judges wanted to rehear the case. And the case or the decision is worth reading, because sometimes they just reject it without comment. But here it was a split decision, and the dissent was vociferous, despite the law being clearly on our side. But the Fifth Circuit got it right. And I'll read you a part of the decision from the majority, or one of the majority judges. and this is a killer here. According to the dissenting opinion, states should be free to accept ballots for as long as they'd like after Election Day. That is, of course, a question for Congress. But even if it were a question for federal judges, do our dissenting colleagues really think that federal law imposes no time limits at all on ballot acceptance? True, statutory deadlines prescribe dates by which the certification of presidential electors must occur. At best, those provide a last-ditch backstop several weeks after Election Day. At worst, they permit states to engage in gamesmanship, experiment with deadlines, and renew the very ills Congress sought to eliminate: fraud, uncertainty, and delay. And nothing whatsoever prevents the states from innovating with ever later ballot receipt deadlines, 2 months or even 2 years, after Election Day in congressional elections. The dissenting opinion's only response is to say, states are unlikely to do that. But such pragmatic assurance only underscore that the dissenting opinion lacks any legal limit. So, as a result of this decision, that's the law of the land, at least in the Fifth Circuit, is you can't be counting ballots that arrive after Election Day. Louisiana, there are 3 states in the Fifth Circuit. Louisiana doesn't do it. Mississippi did do it 5 days after Election Day, so they have to stop now. At least that's my understanding. Now, they could appeal to the Supreme Court. I don't know what's going to happen next. And in Texas, they count ballots that arrive for up. They let ballots arrive the day after Election Day, and they count them. So Texas is likely going to have to change their law as well. So it's an important decision. It further solidifies our case in California. It solidifies our case in Illinois. And hopefully it sends a signal to the other. Mississippi's one state. I think there are at least 18 other states. 19, I think, if you include D.C. They count ballots that arrive after Election Day. It's not like it happens all over the country. It's less than 20 states. And it needs to stop. Either you have an Election Day or you don't. And as the dissent notes, if you don't, all bets are off. So a great decision. Kudos to our lawyers in our election division here at Judicial Watch. We've got former DOJ attorneys. Russ Nobile was on this case. Our election division is run by Robert Popper, former DOJ attorney, civil rights attorney. Just great work by our legal team. This is a momentous, historic set of decisions obtained by your Judicial Watch on a matter of national importance. If we have elections that can be rigged or treated in a way that the American people can't have confidence they're not fraudulent, it's the end of our country. An essential first step to restoring the rule of law on elections. And if you're supporting our work, thank you. We couldn't do it without you. And if you're not, this is a pretty good reason to do so. But before I move along from this, there was a fun part of the decision, because one of the judges wrote a decision attacking big law. And I'm going to read from it because it's not apropos necessarily of the underlying claim, but he really calls out the machinery of the left that comes in and fights Judicial Watch in these types of cases. And it's written by Judge, I think it's James Ho. It's James C. Ho. He's a circuit judge. This is not the first time, and it surely won't be the last, that opposing political interests will cross swords over whether and how election deadlines should be enforced. Our court reached the same outcome that we do today. That is, we set aside a state law because it conflicts with deadlines set by Congress. The Supreme Court unanimously affirmed, so we applied the same principles to the state law challenged here. And he's referencing another case, Foster versus Love, which I'm not sure what that case is. But this is what he goes on to say. My distinguished colleague, I guess one of the judges, nevertheless suggests that this case may be unusual and thus remarkable because, quote, top-flight lawyers unaffiliated with the parties have seen fit to offer their views on this case pro bono. The implication is that the panel decision may be so off the mark that leading members of the profession have felt compelled to speak out. But there's another explanation, Judge Ho writes. The pro bono activity, pro bono is meaning that no one paid them to do it, meaning it's volunteer, in this case may just reflect the institutional bias at many of the nation's largest law firms. Meaning they're all a bunch of libs. That's what Judge Ho's saying. Who are you fooling? Legal scholars have documented how major law firms consistently favor one side in highly charged disputes like this. The evidence has led to the belief that major firms are falling short of the great traditions of the profession. The concern is that they have abandoned neutral principles of representation and instead engage in ideological or political discrimination in the cases they're willing to take on. Moreover, professional traditions may not be the only thing that firms are failing to uphold. 2 years ago, the Justice Department advised our court that much of the institutional bias at major firms may also include workplace policies that discriminate on the basis of race or sex, yet remain fashionable in many legal circles. To be sure, evidence of political and other forms of bias doesn't by itself make a particular legal position right or wrong in any given case, but it does mean we shouldn't be surprised when top-flight firms consistently jump in on only one side of politically charged disputes, including this one, whether the law actually supports their position or not. Nor should the firms be surprised when others take notice that they are no longer abiding by the principles of their profession and react accordingly. And he says that we should treat their work as motivated lawyering designed to reach a predetermined result. And whatever firms may, quote, choose to do, our duty as judges remain the same, to apply the law in a consistent and principled manner, regardless of whose ox is gored. That includes resolving conflicts between state law and the Constitution, no matter what some lawyers say about it. Whoa! How do you like that from Judge Ho? Judicial Watch has been operating for 31 years, and I'm not aware of any major law firm ever giving us free pro bono work. All of our work has been done independently or with working with small or medium-sized firms that we pay. I mean, forget about even getting free help from these big firms. I don't think they would even take us on as a client or our clients on as clients. But all of these big firms all jump in to help the left time and time again. And it shows you the importance of Judicial Watch and the fact that we have strong support and are able to hire our own lawyers on staff and hire lawyers from the outside where it's needed. I mean, we're lucky. We're lucky because of your support to be able to do that. Because all the money, the big law, are on the side of the left, as Judge Ho aptly demonstrates in this remarkable few pages. So you can read the full en banc rejection of the request for rehearing below. We'll put a link there below. But great news for the rule of law. And it's just the beginning. We've got 3 cases we're currently pursuing to stop the counting of ballots that arrive after Election Day. The Fifth Circuit action is an historic victory for honest elections. And now federal law sets Election Day, not Election Week. California and 17 other states should take notice as I noted earlier. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.